You make things. It's what you do. You put in late nights and early mornings and your very soul into creating something new. You take a photo that freezes a perfect fleeting moment. You write a story that builds a world inside someone else's head. You compose a melody that gets stuck on repeat in their mind. You share these creations, sending them out into the vast, chaotic digital world. But what happens then? Copyright is not some dusty legal tome meant for corporate lawyers in tall glass towers. It is a powerful, practical tool designed for you, the creator. It is your invisible armor. It gives you control over how your work is used, ensuring you get credit and, crucially, get paid for use of your property. It's the framework that lets you decide the terms of engagement with the rest of the world. Understanding this tool is not optional anymore. In a world where a click can copy and distribute your work to millions in seconds, ignorance is not bliss, it's a liability. Knowing your rights is the difference between building a sustainable creative career and watching your best work get used to enrich someone else. This is not about locking your work away in a vault, hidden from sight. It is about being a savvy navigator of the digital landscape. It's about having the confidence to share your work widely, while still retaining the power to direct its future. When you understand copyright, you can make informed decisions, you can collaborate on your own terms, you can build a business around your art, you can fight back when your work is stolen. It is your right and it is your power. Let's demystify this. Copyright is not something you have to apply for or win in a contest. It is an automatic right that springs into existence the very moment you create something original and fix it in a tangible form. That's the key. You have an idea for a song but it's just in your head? No copyright. You hum it into your phone's voice recorder or scribble the notes on a napkin. Bingo. Copyright is born. It is the legal recognition that you are the author of a work. This right is granted by law to creators of literary, dramatic, musical, artistic, and certain other intellectual works. It happens instantly, without you needing to fill out a single form or pay a fee. It is your default setting as a creator in the modern world. This automatic right gives you a specific bundle of exclusive powers over your creation. Think of it like a set of controls. You have the right to reproduce your work. You have the right to prepare derivative works, like a movie based on your book or a remix of your song. Your rights aren't without limits, but you'll see, they're still extremely powerful. You have the right to distribute copies to the public by sale, rental, lending. You also have the right to perform or display your work publicly. These rights are yours and you should understand them well. You are the master of your creative domain, and you get to decide who gets a key and under what conditions. It is the legal backbone that supports your authorship. It's important to understand that this is a system of control, not a total ban. The purpose of giving you these exclusive rights is not necessarily to encourage you to hoard them. It is to give you the authority to manage how your work spreads. You can choose to exercise these rights yourself, or you can grant permission, a license, for others to use them. You can charge money for that permission, or you can give it away for free. You can grant permission for one specific use while retaining all other rights. For example, you can license your photograph for use on a single book cover, but not for t-shirts or advertisements. You are in the driver's seat, making the strategic decisions about your work's journey through the world. So, what kind of creative work gets this automatic protection? The scope is incredibly broad. Copyright protects original works of authorship. The key word here is original. It means you didn't copy it from someone else, and it has at least a tiny spark of creativity. Not a high bar for genius. A simple doodle can be protected. The law protects the expression of an idea, not the idea itself. It's the specific execution that matters, the tangible form your creativity takes. Types of works protected include blog posts, poems, novels, scripts, photographs, digital illustrations, paintings, graphic designs, melodies, lyrics, sound recordings, short films, YouTube videos, animations, even computer code and software. Protection can also extend to specific arrangements of words, songs, or even lines of code. Photos are protected, articles are protected, graphic designs are protected. In most circumstances, copyright lasts the creator's life, plus decades, often 70 years, creating a legacy for your family. This long duration makes your creative work a long-term asset. It's not just today's post, it's a protected library with lasting economic value. Here's what copyright ignores. Copyright does not protect ideas, concepts, principles, or discoveries. It also does not protect facts, formulas, raw data. Short phrases, names, and titles are generally not protected by copyright. That's trademark territory. Purely functional or minimal works are not copyrightable. And once a work is in the public domain, it's free to use. Section 5. Putting copyright to work for you. First, mark your work. Use the C in a circle. Add it to your site, your photo metadata, your ebook, everything. Second, keep records, drafts, raw files, session files, and date-based file names. Even email yourself a copy. This may not prove a copyright, but it helps with evidence. Third, think like an owner. Structure permissions, create price exclusivity, or use platforms like Creative Commons to share your works. Finally, communicate professionally. A calm note can resolve issues and even create customers. Use your power wisely to build your career.